Major breaking news. The United States Court of Appeals for the 8th Circuit out of St. Louis, the Midwest, has found in a 3-0 decision that Missouri's Second Amendment Preservation Act, which essentially makes the state of Missouri, or Missouri, depending on where you're from, into a Second Amendment sanctuary state, has been found to be unconstitutional under the Constitution's Supremacy Clause. But let's talk about what it really means in the real world when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. We must always learn from the mistakes of others and the good and the bad choices that people have made over time. And there's a lot to be learned from the Jews' relationship with firearms, private firearms, over time, and also in Israel between the founding of their country in 1948 through today, where prior to 10/7, 2023, they got a little complacent, relied too much on government in my view, and they should have relied a little bit more upon themselves and private firearms. I talk all about it in the book, Israel Disarmed. All right, folks, so the United States Court of Appeals for the 8th Circuit out of Missouri, Minnesota, Midwest, has found in a 3-0 decision that the Missouri Second Amendment Preservation Act, which classified various federal laws to be unconstitutional and to constitute an infringement of the Second Amendment, the 3-0 decision by the 8th Circuit has found this act to be unconstitutional and in violation of the United States Constitution, specifically that part of the United States Constitution known as the Supremacy Clause, that says that federal law is supreme, which means that to the extent a state law and a federal law are in conflict, the federal law, as a general matter, controls, and the state law must fall by the wayside. The United States of America, Merrick Garland, Joe Biden, Kamala Harris sued the state of Missouri after they enacted this law in 2021 to try to preserve the Second Amendment, and they sued the state of Missouri, the Attorney General Andrew Bailey, and the governor of Missouri, all arguing that this violated the Constitution, and it went all the way up to the 8th Circuit. And the court said, indeed, that this violates the Constitution. But not all is terrible. Before I get to the explanation why not all is terrible, and maybe there's a better way to do these sort of sanctuary arrangements with the federal government, which I will give you some ideas in just a minute or two, I just want to tell you what the law specifically said. Under the 2021 Act, the state of Missouri called the law the Second Amendment Preservation Act, and it provided as follows. The following acts, laws, executive orders, administrative orders, rules, and regulations shall be considered infringements on the people's right to keep and bear arms, as guaranteed by Amendment 2 of the Constitution of the United States and Article 1, Section 23 of the Constitution of Missouri, within the borders of the state, including but not limited to any tax, levy, fee, or stamp imposed on firearms, firearm accessories, or ammunition not common to all other goods and services, and that might reasonably be expected to create a chilling effect on the purchase or ownership of those items by law-abiding citizens. Any registration or tracking of firearms, firearm accessories, or ammunition. Any registration or tracking of the ownership of firearms, firearm accessories, or ammunition. Any act forbidding the possession, ownership, use, or transfer of a firearm, firearm accessory, or ammunition by law-abiding citizens, and any act ordering the confiscation of firearms, firearm accessories, or ammunition from law-abiding citizens. The act declares these federal laws shall be invalid in the state of Missouri. Now, there's a lot of good thoughts in that act, and I applaud Missouri for trying to do something, so that's fine. But legally speaking, I'm going to talk about legally for a moment, and then I'm going to tell you how I might have drafted the law, or what I might do if I were in charge of Missouri, which I'm obviously not. It is likely true that the way this law was sort of designed may very well have violated the Supremacy Clause by saying basically we're not going to respect or have a Missouri residents respect federal law, and that arguably is a problem. With that said, I think the motive and intent is well, because I think it's fair to say that federal law enforcement is over the top now when it comes to our Second Amendment rights. And by the way, because you come to this channel for me to connect dots that other channels will generally not connect. Let me connect a dot for you here. I'm not sure if you're familiar with what's been going on with President Trump's campaign, but Donald Trump, as the nominee for the Republican Party to run for the White House, he is legally entitled to, and is entitled to as a matter of custom, tradition, to receive weekly national security briefings from the federal government's national security apparatus. Donald Trump, however, is refusing to sit down and hear these briefings. Why? Because he doesn't trust the deep state. He doesn't trust the FBI. He doesn't trust the CIA. He doesn't trust any of those worker bees that work for the Defense Department or work for the D.C. establishment on behalf of the government, because he knows they're out to get him. In fact, they're trying to put him in prison with like the Jack Smith prosecution, among other things. So Donald Trump is taking the advice of many of you excellent criminal defense lawyers out there, which I would agree with that advice, which is don't talk to the police, don't talk to law enforcement, don't talk to the government unless you have no choice. And Donald Trump is realizing that there's no upside to him to hear these briefings now, because they're going to either say he said things he didn't say, or they're going to leak information, or they're going to accuse him of disclosing stuff he's not allowed to disclose and use that against him. So it's very wise that Donald Trump doesn't speak to the deep state, even though he's allowed to get these weekly briefings by them. Now, why does that connect the dots to this Missouri Second Amendment Preservation Act? It's because nothing requires, as a general matter, the state law enforcement apparatus in the state of Missouri to be commandeered by the federal government. Now, they have to follow federal law, yes, but they don't have to work for federal law enforcement. So when the feds, the ATF, the CIA, well, it won't be the CIA necessarily directly at least, if the FBI, the ATF, or any of these federal law enforcement agencies go to local law enforcement departments, they go to Ferguson, Missouri, they go to Kansas City, they go to St. Louis, they go to, any of these, Columbia, whatever it is, and they want to form, let's say, a task force, nothing requires state agents to agree with the task force. They can simply say, yeah, we're not going to talk with you. We're not going to cooperate. We're not going to join in a task force. If you want to find out how you want to solve a crime or do something with the feds, you do it yourself. Nothing prevents you from doing that. And if it involves firearms, then tell them, go pound sand. There's no requirement. In fact, it's unconstitutional for the feds to commandeer state agents as a general matter. There's Supreme Court precedent on that. So that's one thing to do. Say, fine, we're just not going to share information with you unless we're legally obligated to do so. And of course, the related thing is you can also slow things down by saying, we're not allowed to share information with you unless we get approval by our higher ups. And that's going to take approximately the same amount of time to get you that approval as, guess what? It takes for you to get a concealed carry permit in California, or a concealed carry permit in New York, or concealed carry permit in New Jersey, or Maryland, let's say. So there's all sorts of ways that the state of Missouri can kind of not cooperate with the feds if this is what they really hope to do when it comes to enforcing firearm laws. Because as a general matter, the feds don't know a lot about what's going on the ground. And in my view, we should cut federal law enforcement dramatically in terms of we don't need them, because the truth is state and local law enforcement are really the ones that we need to go after the violent thugs on our street. But again, that's the purpose of another video. Now, the other thing is, if you are concerned about federal gun control laws, and I made this observation at the Gun Owners of America conference last week or so when I spoke in Knoxville, Tennessee, because people asked me about this, and here's what I said. If you really want to mess with federal gun control laws and you're running a state like Missouri, the way I would look to do it is take advantage of the exception to every rule in all these federal gun control laws. What is that exception? These exceptions say that you can't have a machine gun, you can't have a new machine gun, you can't do this, you can't do that, unless you are law enforcement. Law enforcement. If you're law enforcement, there's all sorts of things that you get to do, including concealed carry nationwide under LEOSA, HR 218 or whatever it is. You guys probably know better than I do. There's all sorts of things that law enforcement agents can do. So what I flagged was the possibility of the state of Missouri, or any state for that matter, designating every resident in the state to be state law enforcement. Why not? You don't have to necessarily pay them either. You can make everyone a Missouri state trooper, let's say. but they only get paid if they work. And if they don't work, because there's no work available, so be it, but they're still law enforcement for the state of Missouri. And because they're law enforcement for the state of Missouri, well, it seemed to me they fall within all of those federal gun control law exceptions that say that if you're law enforcement, you can have a magazine that's more than 10 rounds. If you're law enforcement, you can carry a gun into this state or that state. You see what I'm saying? That is how I would be thinking about this problem. I'm not saying that's perfect, but this is how I'd be thinking about the problem if I were advising a state like Missouri or Florida or Texas or whatnot and looking to do something along these lines with the feds, if this is what you're really trying to accomplish. Of course, you can also make it clear that all budgets or all monies that comes from the state of Missouri to local law enforcement cannot be used to fund any cooperation with the federal government or federal law enforcement involving firearm laws. Again, if that's what you're trying to do, look to deal with it in terms of the budget. Or relatedly, to say that no task force can be entered into between a local law enforcement agency in Missouri on the one hand and a federal agency on the other hand without the sign-off of the Attorney General of Missouri himself or herself. And of course, that might take several months, if it involves guns, before you will even get an answer back. Again, it should take approximately the same amount of time as it takes to get a gun concealed carry permit in the deep blue states. I think that's how I'd be thinking about this. So anyway, the bottom line is the Eighth Circuit said that the Missouri law violated the Constitution, violated the Supremacy Clause. I'm not surprised with that outcome. With that said, I do think there's ways to get creative here to prevent the feds from being able to enforce what are obviously unconstitutional violations of the Second Amendment. Again, there's probably a lot of other things that I'm not thinking about. I just thought of these ideas really kind of off the top of my head. I haven't done deep research on this, but certainly if I worked for the Attorney General's office in some of these states, this is what I would be thinking long and hard about and researching to find a way to prevent the infringement of my citizens, of my residents' Second Amendment rights, and prevent this crazy enforcement that we're seeing against all sorts of people, including President Trump, given what happened. I mean, the guy had Mar-a-Lago invaded over documents. How absurd is this? But that's what we're dealing with when you're looking at federal law enforcement. It's not a good look. I've said this about DOJ. It's just not a good look. You want Americans to respect what you do. You don't want Americans to view you as anything other than honorable and upstanding and following the law. And over the last several years, I think there's a lot of damage, in my view, that has been done to the reputation of DOJ. And I think Merrick Garland at the head of this probably deserves quite a bit of the blame for guiding the DOJ down this path. But, you reap what you sow, and here's where we are if you're federal law enforcement. It's just the way it is. Okay, folks, hope you learned something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner, and we will see you again very soon, I hope, the Four Boxes Diner.
Orders up. Table 2A.